to know how to cook. I gave up watching the cooking shows on TV because I don't have the time or the skill or the knowledge to cook the way they do. I love going to a good restaurant though and dining on something special. They say that if you want to cook, first you need to learn how to follow a recipe exactly. Measure everything out carefully, set the oven to the prescribed temperature, set a timer, follow the rules, follow the plan. Eventually, once you really understand what's going on, then you can start to get creative. Start out with the recipe and you can have confidence in what you cook. Wouldn't it be great if there was a legal recipe? A way of making legal decisions, a process we can follow, at least until we develop enough serious skills to start being creative? Well, there is. In fact, there are a number of legal recipes out there, but the dominant one is called the IRAC model, IRAC. Those letters stand for issue, rule, application, and conclusion. If you follow the IRAC process of reasoning, you can break down virtually any legal issue and provide a sensible response. G'day everyone, my name's Anthony Marinac and welcome to Module 4 of our Introduction to Law. In this module, we're going to talk about how to think, analyse and argue like a lawyer. In this first video, we'll take a practical scenario and we'll apply the IRAC reasoning process to it to show you how simple and yet how powerful this process of reasoning can be. In the second video, we look at techniques of persuasion and advocacy, because IRAC is pretty good when you're just presenting your reasons on their own. But our court system is adversarial, and so there's always going to be someone arguing the other side's case, and they will use IRAC reasoning of their own. And you need to have some ways to show anyone who's listening that your IRAC argument is superior to their IRAC argument. In the final video, we're going to delve very briefly into the world of evidence, because that's where all the facts come from. The facts that you'll be applying both in your IRAC reasoning and in your persuasive analysis. Now, it's going to be complicated and frankly pretty boring if we just talk about IRAC in the abstract. So instead, we're going to apply IRAC to a scenario, and then we'll work through that scenario for the rest of this module. For those of you who already have some legal knowledge, bear in mind that the purpose here is to learn IRAC, not to learn the actual law. So please forgive the oversimplifications, okay? Now, grab some popcorn and watch this Emmy quality theatre.
I think I need to see your manager, please. Absolutely. Just let me grab him.
What's going on?
I had an iced latte here yesterday, and I think the milk was off. Or something. I started feeling sick on the way home, and had a sudden attack of violent vomiting while I was driving. I ended up running off the road and into a ditch. My car is totaled.
Look, I'm sorry that happened, but I really don't see how this is my fault. How do you even know this had anything to do with me?
I hadn't eaten anything since breakfast when I came in here. 10 minutes after I had my drink, I was sick. I have a written food poisoning diagnosis from the doctor. So what are you going to do about my car?
You know what? I'm not going to do anything. I don't think this is my problem. But if you're really convinced that it is, then you can send me a letter and I will go see my lawyer. I'm sure not going to stand here in the middle of the shopping center arguing it out with you. You're scaring away the customers.
Oh, you'll be hearing from me, all right.
Seriously, that's the last straw. I leave you to run the shop for one day, and now there's a customer suing me. Did you even check the dates on the milk? Actually, you know what? Never mind. I don't think I believe you anyway. Enough is enough. You don't even need to finish the shift. Just go. I'm firing you.
You're firing me? That is totally unfair. For your information, I did check the dates on the milk, like I do every morning. And I have been telling you for ages that the fridge was on the blink and that the temperature gauge showed it at 3 degrees when it was actually a lot warmer. You didn't want to believe me and now suddenly I'm getting the sack? Stuff that. I'm going to Fair Work Australia over this. I know my rights. So how can I help you today?
I'm so bloody angry. I'm about to get sued by a customer and by one of my employees. I run a cafe. You'd think that'd be easy enough, but I'm in all sorts of a mess now. They're both bloody idiots.
Okay, I'd certainly like to help if I can. Would you like to start with the customer or with the employee?
The customer, I guess. She reckons we gave her food poisoning. An iced latte with bad milk. It's rubbish. And then she crashed her car while vomiting, and that's supposed to be my fault.
Well, do you know for sure she was sick?
Yeah, she was sick all right. She's got a doctor's report. And a receipt for the iced latte. I mean, who keeps receipts from a cafe? But who knows what else she's eaten?
Well, that's true. But you must be worried or you wouldn't be here.
Yeah, well, here's the thing. We've been having this issue with one of the fridges. Just randomly goes on and off, sometimes overnight. Something to do with the thermostat or something. I need to replace it, but fridges are bloody expensive. So the staff are supposed to check the temperature at the start of each shift.
Okay, so it seems quite likely that she might in fact have gotten food poisoning. We can work through that though. What about the employee?
Well, she's just useless. I've been thinking about sacking her for ages. She was the first one in on the day in question and was supposed to check the fridge temperature. She can't have done it properly, or we'd have known the milk was off.
How, though? Could the fridge have turned itself off overnight and then back on before the start of trading the next day? And do you know whether the temperature gauge on the fridge was working fine?
Aren't you supposed to be on my side?
So there's our legal situation. We've got a client who's in a pickle. They haven't actually been sued yet, but they're expecting it to happen, and they need our help. Let's work through the IRAC process and see what we can do. The first question in any legal analysis is to identify the dispute. This is not always as easy as it might seem. Now, there are a few ways to work out the issue. Sometimes it will jump out right at you. Other times you'll have to work a little harder to find it. I find that there are three important questions to ask when you're trying to identify the dispute. The first one is, what are the key points of disagreement? Now, these are not actually the issue, because not every dispute is a legal issue. But if we start by identifying the points of disagreement, we can work our way inwards from there. So what are the points of disagreement in this dispute? Well, there are a few. First, did the customer actually have food poisoning at all? Second, was the food poisoning actually caused by our client's iced latte? Third, if the customer did actually have food poisoning, was it the food poisoning that caused the accident? Fourth, if there was food poisoning caused by our client's iced latte, what caused the milk to go off? And finally, if the milk went off because the employee didn't do their job properly, was it okay to sack her? Now, none of these are really legal questions as such, but you can see that by identifying these points of dispute, we're starting to wrap our heads around what the issues might be. The second question is, what does the plaintiff want? The plaintiff is the person who is suing. Sometimes that'll be our client, and sometimes it will be the other party. You see, the point of going to court is to obtain a remedy, whether it's compensation or a court order or something entirely different. If you're not trying to obtain a remedy, then the court will really not help you. So focusing on the remedy sought by the plaintiff is a good way to focus on the issues. Now, in this case, we've potentially got two plaintiffs, the customer and the employee. We're just going to focus on the customer for the moment. Later on, I'm going to get you to try the IRAC process for the employee on your own. So what does the customer want? Well, the customer wants compensation. Compensation for their sickness and compensation for the damage to their car. The third question to ask is what the defendant wants. Now, most of the time, as in this case, what the defendant wants is for the whole issue to go away. But that's not always the case. Sometimes the defendant might admit they're responsible, but they might dispute, say, the amount of compensation being asked for. So understanding what the defendant wants is important too. In this case, the defendant simply wants the action to be dismissed. So now we can sum all of this up and identify our issues. The first one is whether the manager, our client, is liable for the customer's food poisoning. The second is whether the manager is liable for damage to the customer's motor vehicle. Can you see how these really are the centre of the dispute? Those, then, are our issues. Now, a word of warning before we move on from the issue. Lots of students learn IRAC during their introduction to law and then they promptly ignore it ever afterwards. They jump straight to the first thing that looks like an issue without stopping to be systematic about it. As a lecturer, one of the most common errors that I see in student papers, particularly for new and beginning students, is that they fail to properly identify the issue. Lecturers will sometimes insert what we call red herrings, things that look like an issue but really aren't. For instance, in our scenario, if I had mentioned that the customer was a gang member or a child pornography distributor, those things would have jumped out at your legal mind, but they're actually quite irrelevant. So it's very important that you carefully and systematically identify the issue. Mark that up and it's going to be very, very hard to recover. Okay, so we know our issues. Is the client liable for the food poisoning and are they liable for the motor vehicle damage? Our next step is to identify the rules. Again, there are a few steps. The first of those is to ask ourselves, to which general area of law does each issue belong? Now, if you were a solicitor in private practice, you'd be expected to have a pretty good idea of this for yourself right off the bat. However, as a law student, you're always going to have a super huge hint in the form of the name of the subject you're studying. If you're studying criminal law, I reckon it's going to be an issue in criminal law. If you're studying contracts, well, I reckon there's going to be a contract law issue in there. Now, that doesn't mean some issues don't cross over into other areas of law, and there's no reason you can't show off just a bit by demonstrating to the marker that you understand that. But let's face it, the purpose of doing an assignment is for you as the student to give us as lecturers excuses to give you marks. If the assignment is in your contract subject and we're testing your knowledge of contract law, show me how much you know about contract law. So that's where the rule is going to be. So in this case, thinking it through, I reckon there are two real possibilities. The first is that the rule is going to be somewhere within contracts, and particularly within an area called the Australian consumer law. The second possibility is that the relevant rule could be within a tort called negligence. Now, in this video, we're only going to look at the consumer law issue because I'm sure you don't want to be watching this for hours. However, I'm sure you do want to be working on your assignments for hours in order to score the great marks. So you would look into both for an assignment. How do you do that? How do you find the rules? Well, there are a few ways. As a student, first and foremost, you should be relying on your notes and your textbook. Even as a practitioner, most practitioners rely heavily on appropriate textbooks. Yes, folks, there's going to be some reading involved. Another way, and a way that I want to show you briefly now, is to use what's called an online legal encyclopedia. There are two main ones that you'll come across. One is simply called Laws of Australia, and the other one is called Halsbury's Laws of Australia. Now, I'm going to use Halsbury's because that's where I'm comfortable. But for yourself, well, you should check both of them out. Halsbury's sits on the Lexis Advanced Pacific platform, which most universities will have access to. I tend to find browsing rather than searching works best for me, so from the main screen for Halsbury's, I select Browse, and that brings up all the headings of each of the books of Halsbury's. Let's start with contract law and the Australian consumer law. Now, we could go into this book called Contract, but I reckon this one here, called Consumer Protection, is even more likely to steer us in the right direction. Now, here's where things get a little tricky. Because I've been a good student and studied before doing this assignment, I already know that in the consumer law, there are these things called implied terms and implied guarantees. If you didn't know that, then you'd just have to keep opening up elements of the browser tree until you start to come across contents that suggest you're on the right track. it's always going to be the case that the more knowledge and understanding you bring with you to the research process, the quicker and easier you'll find it to undertake your research. Now, if we open the section on implied terms and guarantees, we then select Commonwealth, because again, as good students, we know that the Australian Consumer Law is a Commonwealth law, which all of the states then apply. We can then see a whole bunch of consumer guarantees. Now, the iced latte is a type of goods, isn't it? It's an actual thing that the consumer was buying from our client. So we look at the guarantees for goods, and there are a couple of guarantees which are going to be very interesting to us. Acceptable quality and fitness for purpose. Now let's concentrate on acceptable quality. We open it up and look at this amazing information. It's telling us the rule. It says, under the Australian Consumer Law, or the ACL, if a person supplies, in trade or commerce, goods to a consumer and the supply is not by way of auction, there is a guarantee that those goods are of acceptable quality. Goods are of acceptable quality if they are as 1, fit for all purposes for which goods of that kind are commonly supplied, 2, acceptable in appearance and finish, 3, free from defects, 4, safe, and 5, durable. As a reasonable customer, fully acquainted with the state and condition of the goods, including any hidden defects, would regard as acceptable, given the nature and price of the goods, any statements made about the goods, including statements on the packaging or label of the goods, or representations made by the supplier or manufacturer of the goods, and any other relevant circumstances relating to the supply of the goods. All right, there was a lot of that in there. But now we know the rule. We can get on with applying it, right? Not so fast, buddy. You see, every lecturer and every examiner in every subject you ever do will look at every rule and ask, what is the authority? In other words, where does that rule come from? Now, if you say, my lecture notes, then you lose marks. If you say Halsbury's, you lose marks. If you say my textbook, you lose marks. You see, for most subjects, and certainly for all first year subjects, there are only 3 sources of authority: the Constitution, legislation, and case law. That's why we've spent so much time in the first 3 modules discussing them. So before we can cite these rules in our assignment, we need to know where they came from. Let's go back to Halsbury's. You can see that here at the start of the rule there's a footnote. It tells us that the rule being cited in Halsbury's comes from the Competition and Consumer Act 2010, Schedule 2, which I know from experience is the Australian Consumer Law. And then it says Section 54. It's also helpfully telling us that the Australian Consumer Law contains some relevant definitions that we'll need to look at. So we can jump either to AustLEA or the Federal Register of Legislation, find the Competition and Consumer Act 2010, scroll down to Schedule 2, open it up and go down to Section 54. There's the authority for our rule. So we've had a look at the facts, and from those facts we've identified the issue. Now we've identified the rule that's relevant in this situation. We don't necessarily understand the rule yet, but we've identified it. Next, we apply the facts to the rule. Now at this point we need to start thinking about persuasion, because we not only need to show that we've applied the facts to the rule, but we want to show that we have done so in the best and most convincing way possible. There are different techniques, but my recommended technique is both simple and thorough. We break down the rule into its tiniest elements, and then we look for facts relevant to each of them. So let's do this for our example, breaking down Section 54. We can break it down into a whole bunch of elements. Number 1, if a person. Number 2, supplies. 3, in trade or commerce. 4, goods. 5, to a consumer. 6, not by way of auction. 7, then there is an acceptable guarantee that those goods are of acceptable quality, meaning, relevantly. 8, fit for all purposes for which goods of that kind are commonly supplied. 9, free from defects. 10, safe. 11, as a reasonable consumer would regard as acceptable. 12, given the nature and price of the goods. 13, statements made about the goods. And 14, any relevant other circumstances. So you can see the rule actually breaks down into no less than 14 separate elements, all of which should be considered if we're going to do the job thoroughly. Let's look at how we do that. The first one is if a person, well in this case either the manager, our client, or the firm is going to be the relevant person. You see, a business, a company, is what's called a legal person, having many of the same rights and duties as a natural person. Second element, supplies. If we go back to our Australian consumer law, we find in the definitions that there's a definition of supply and it includes sale. So there has been a supply. Third element, in trade or commerce. The Australian consumer law has a definition of trade or commerce, but it doesn't really help us very much. This is trade or commerce within Australia, but the fact that this is a sale by a store to a customer makes it pretty clear that this is trade or commerce. It's not like one person was making an iced latte for another one in the kitchen at home. So we're on pretty safe ground here. Next element, goods. Again, the Australian consumer law includes a definition, but it's not much help to us. So we go instead to the normal meaning of the word. Goods are physical things that are bought and sold. No reason to think that an iced latte wouldn't fall into that category. Next element, to a consumer. Now, the Australian consumer law has some pretty clear rules about who is a consumer. I don't want to turn this lecture into a mini contract lecture, but basically the person has to be purchasing things which are normally used for personal or domestic consumption, which cost less than $40,000, and which they're not intending to resell or use in the course of their business. Well, unless it's the world's most expensive iced latte, I'm pretty sure that makes our customer a consumer. The next element, not by way of auction. Well, there's no suggestion here that the iced latte was auctioned off. So all of those elements are met to this point. The next element tells us that because all of those previous elements were met, there is a guarantee that those goods are of acceptable quality. So what this tells us is that once all of the boxes above are ticked, which they are, then a guarantee sprang into existence about the latte. Now that guarantee has a number of elements. We're going to ignore the ones that are patently irrelevant and focus on the ones that might matter in this case. Fit for all purposes for which goods of that kind are commonly supplied. Well, now this one's a bit contentious, isn't it? I mean, pretty clearly the normal purpose of an iced latte is to be drunk. If this particular iced latte was made with milk that was off, then it wasn't fit for the purpose of being drunk, and the guarantee will be breached. However, if the customer can't actually show that the iced latte was made with off milk, then the customer may not actually be able to demonstrate that this guarantee has been breached. Okay, free from defects is the next one. This is pretty much a rerun of the last guarantee. If the iced latte contained bacteria causing food poisoning, well, that's pretty clearly a defect, wouldn't you say? Again, though, they'd have to prove it. The next element is safe. And at the risk of getting monotonous, this is pretty much the same situation all over again. If the iced latte contains bacteria causing food poisoning, well, it's pretty clearly not safe. There are a few more tests for those guarantees, though. First, there's the reasonable person test. Would a reasonable consumer have regarded the iced latte as being of acceptable quality? Well, if there were food poisoning bacteria in there, certainly not. If there were no food poisoning bacteria in there and the iced latte was fine, then certainly the guarantees were met. Second, we consider the nature and price of the goods. Not really relevant here. It's not as though, for instance, the iced latte was on sale because it had been made a few hours ago or anything like that. Third, we consider any statements made about the iced latte. Again, not really relevant. If our barista had told the customer, look, I'm not sure about the milk, but if you really need a coffee and can't wait for me to buy more milk, then I'll make you some with yesterday's. Well, if she'd said that, then maybe the situation would be different, but there's no suggestion that any such thing happened, and the last thing we want to do is to start making up facts. So you can see we've reached the point where we have a really solid understanding of the issues, the facts and the law. And we've put them all together in a way that will allow us to draw conclusions. The thing with conclusions is that they require courage. It's so tempting, isn't it, to just try to hedge your bets. It'd be so tempting in this particular exercise to conclude by saying something like, if all of the required elements of the Australian consumer law are met, then our client will be liable. But really all that does is restate the question. To conclude, you have to actually conclude. So what would your conclusion be in this case? Mine would probably be this. If all the relevant facts were known to the court, our client would likely be considered liable for food poisoning. While it cannot conclusively be shown that the iced latte caused the plaintiff's illness, the fact that the iced latte was made with milk which was kept overnight in a defective refrigerator suggests that on the balance of probabilities, her illness is more likely than not to have arisen from the milk. Now, having given a clear conclusion, it's then perfectly okay to reflect on other possibilities. In fact, if you have room within your word count, I'd highly suggest this because it means that if your conclusion turns out not to be correct, you can still rack up marks from your alternative. So your alternative might be something like this. However, it may be that the customer will find it difficult to show that the refrigerator was not working. If that fact is not before the court, or if further evidence emerges to show other likely sources of food poisoning, for instance, if the customer ate food from a bain-marie in another store, then our client may not be found liable. On balance though, I consider that our client is likely to be liable. One more thing about conclusions. Did you notice that it looks like our client is not going to win? This is something university lecturers often do. Beware of finding yourself in the situation where your competitive instincts take over and you try to make your client win at all costs. You're not meant to simply be the client's champion going off to fight on their behalf. You're meant to be their advisor. And if the correct, proper advice is that they're in awfully big trouble, then that's the advice you have to give them. In a criminal matter, that will let them consider an early guilty plea, which will reduce their sentence. In a civil matter, that will let them consider making a settlement offer to the other side, potentially reducing their costs. Okay, so now we've completed the IRAC process for one of the issues which we identified on these facts. What does it look like when you bring it all together? Most of the time at university you'll be required to bring all this together in a written answer to a problem question. That'd be pretty boring on a video though. So here's the full IRAC in the form of our lawyer advising the client.
I've done the analysis and I have some advice.
Okay, hit me with it.
I've had some time to look at the issues you've raised regarding the customer. There are really two key issues. The first is whether you are liable to her at all for the food poisoning, and the second is whether you are liable for the specific claim she's making regarding the damage to her car.
Well, that makes sense.
I'm going to start with the food poisoning. Because you are selling goods to customers, mainly beverages, you're bound by the Australian consumer law. In particular, there's a section in the Australian consumer law which says that by selling things to a consumer, you're effectively making a number of guarantees about that product. One of those, which we find in Section 54 of the Australian consumer law, is that the goods have to be fit for purpose.
Can you explain what you mean by that?
Fit for purpose means a number of things. In this case it means the product, the latte, has to be suitable for the normal things one does with a latte, that is, drinking it, and that it needs to be both free from defects and safe. Now we've got a bit of a problem. Because we know the fridge wasn't working effectively, and even though we might know what the temperature of the fridge was at the start of trading, we don't know whether it maintained that temperature all night. and we've got some pretty good reasons for thinking it might not have. If that evidence was brought forward, then you can see it would be very easy for the court to draw the conclusion that it was in fact the iced latte that caused the food poisoning.
So I'm in a lot of trouble then?
Not necessarily. It may be difficult for the other side to prove anything about the fridge, but if they directly ask you, in evidence, whether the fridge was working properly, well then you will have no choice but to tell the truth. As a result, I think it's best to proceed as though you will be liable for causing the food poisoning.
I guess so.
The second issue is whether you should be liable for the damage to the car. As a general principle, the Australian consumer law says that if a consumer guarantee is breached, and the breach causes harm to a person, then the supplier will be responsible. The real question here is whether your iced latte was responsible for the crash. There is an old test we use, from a really old case called Hadley and Baxendale, to resolve this. First we ask whether the harm flowed naturally from the breach. I don't think it did. One wouldn't normally think that the consequence of drinking off milk would be totaling your car. Second, we ask whether the parties should have had in their mind the possibility of this type of damage.
Okay, so what does that mean?
Well, there was nothing to suggest that you knew she was about to go driving, or that you should have been particularly more careful as a result. My advice is therefore that the harm to the motor vehicle is too remote from the supply of the off milk, and that you won't be liable for that. In terms of how to move forward, I would suggest we consider making an offer to cover her doctor's bills and perhaps offer a small sum to compensate her for her illness, in return for her agreeing not to proceed to court.
Well, I'm not happy about paying her money. But thank you for your advice. I will go away and think about it.
You can see how the IRAC process well and truly came through for us in that situation. It provided the model for our legal reasoning. Now let's do something even more clever. Remember in Module 3 we spent a lot of time reading Justice McHugh's decision in Green and the Queen? Go back to that case and go back to Justice McHugh's judgment. Look at it again. What did he do? He started out with the facts, and from those facts he identified the issues. He then discussed the rules relevant to each issue. Once he'd done that, he applied those rules to the facts in the case, and then he made his conclusions. He did it in a long, complicated and very thorough way. But when you pare it all back, it was straightforward IRAC. If it's good enough for the High Court, well, it's good enough for me.